Welcome to Law in Layers, where we break down the law one layer at a time. Today, we'll be breaking down the basics of murder. Murder is a common law offense, meaning it is a judge-made law. Lord Coke created the definition in the 17th century, in which murder is the unlawful killing of another human being under the king's peace with malice aforethought. I will begin with the mens rea of the offense, and I recommend you do as well in an exam scenario question, as if the defendant lacks the mens rea, they will likely be guilty of manslaughter. The mens rea of murder is malice aforethought, which is the intention to kill or cause grievous bodily harm, also known as GBH. Murder is an offense of specific intent, so recklessness will not be sufficient for murder. The defendant may have a direct intention to kill, also known as expressed malice, where causing death is their main aim. The defendant may have a direct intention to cause GBH, also known as implied malice, where causing GBH is their main aim, but death occurs as a result. This can be seen in the case of Vickers, where the defendant beat the deaf owner of the sweet shop he had just broken into to death. In this case, it was held that whilst the defendant did not have the intent to kill, the intention to cause GBH was enough to satisfy the mens rea. The final possible intention a defendant can have is an oblique intention to kill or cause GBH. This is where a defendant had some other aim in mind other than death or GBH, but his actions rendered death or serious injury a virtual certainty, and he realized that this was the case. This was demonstrated in the case of Woollin, where the defendant threw his 3-month-old baby to the ground in frustration when it would not stop crying, leading to the baby dying from a fractured skull. The court accepted that the defendant did not intend to cause death or harm to the child, but death or serious harm was a virtual certainty and the defendant appreciated that fact. The Actus Reus of murder is the unlawful killing of another human being, under the king's peace. This requires the death of the victim to be unlawfully caused. A lawful killing is seen as justified. Examples include self-defense, where a patient requiring medical treatment dies because of a surgical procedure or necessity. This was demonstrated in the case of Rhea, children, conjoined twins, surgical separation, where the court famously authorized the surgical separation of the twins, Jody and Mary, knowing it would inevitably cause the death of the weaker twin, Mary, but save the life of the stronger twin, Jody. The court established that the surgeons had a legal defense of necessity against a charge of murder. The judges reasoned that the doctor's primary intent was to save Jody's life, not to kill Mary, and that taking this step was an act of survival for Jody. Murder can be committed through an act or an omission. It must be established that the defendant's act or omission caused the death of the victim, also known as causation. Causation is the link between the defendant's act and the result of the victim's death. There are two types, factual and legal causation. Factual causation asks whether the defendant's act was a factual cause of the victim's death. This is established using the but-for test. Would the victim have died but for the defendant's conduct? This is shown in R. v. White, where the defendant attempted to poison his mother, but she died of a heart attack anyway. The court held he was not guilty of murder because, but for his act, she would have died regardless. Legal causation asks whether it is fair to hold the defendant legally responsible for the death. The defendant must be more than a minimal cause of death, de minimis principle. In the case of Pagett, the defendant used his girlfriend as a human shield during a shootout with police, and she was killed by police gunfire. He was still held liable because his actions were an operative and significant cause of her death. It must be considered in any scenario whether the chain of causation has been broken by a novus actus interveniens, also known as a new intervening act. There are generally two types, medical negligence and the victim's own actions. When it comes to medical negligence, the courts are reluctant to find it to be a new intervening act, as this would cause doctors to be afraid of doing their jobs. This was demonstrated in R. v. Smith, where the court held that if injuries are still the operating and substantial cause of death, the defendant will still be held liable, regardless of the medical negligence. However, in the case of R. v. Jordan, the medical negligence was so palpably wrong that the defendant was no longer the cause of the victim's death, making the defendant no longer liable. This was an extreme case of medical negligence where the victim's stab wounds were healing well, but the doctors administered a drug to which the victim was allergic and gave excessive intravenous fluids. The victim died of pneumonia caused by the medical treatment, not the stab wound. A victim's own actions can constitute a novus actus interveniens. This is established using the daftness test. If the victim's response is proportionate and reasonably foreseeable, the defendant remains liable. If the reaction is so daft or irrational that no reasonable person could have foreseen it, the chain is broken. An example of this being applied is in the case of Roberts, where the defendant made unwanted sexual advances to the victim while driving. To escape, she jumped out of the moving car. The court held her reaction was proportionate and foreseeable, therefore, the daftness test did not apply to break the chain of causation, and the defendant remained liable for her injuries. A case which relates to the offense of murder is of v. Williams and Davis, where the victim jumped from a moving car and died after being threatened by the defendants. The court established that if a victim's escape reaction is panicked but within the ambit of reasonableness to an immediate threat, it is not daft. It must also be mentioned that a defendant must take their victim as they find them. This is known as the thin skull, eggshell rule, which states that if injuries are made worse due to a pre-existing condition on the victim's behalf, the defendant remains liable. A case example for pre-existing medical conditions is Hayward, where a husband and wife had an argument that led to the husband chasing his wife out into the street. The wife collapsed during this altercation and died. While the husband did not physically touch her, he did shout threats at her. The wife was found to have been suffering from an abnormality of the thyroid gland that neither of them was aware of, which meant that fright or shock could cause death if combined with physical exertion. The husband was charged with manslaughter. This rule even applies to religious beliefs, as seen in the case of Blaue, where the defendant was guilty of the victim's death even though she had refused a blood transfusion due to religious beliefs. The defendant will only be guilty of murder if the victim is a reasonable creature in rerum natura, which means that the victim must be a human being. In relation to babies and fetuses, the case of Poulton established that a baby is a reasonable creature in being when the whole body of the child is brought alive into the world. Once the child has completely left the mother's womb and has lived outside the womb, it is capable of being a victim of murder. The child is in being even if the umbilical cord has not been cut, as stated in Reeves. However, a fetus in its mother's womb is not a reasonable creature in being and, thus, is not capable of being murdered as seen in Attorney General's reference, No. 3 of 1994. In relation to end-of-life situations, the case of Malczarek and Steele, it was held that brain death is a legal death, so if a doctor turns off a life support machine, the defendant will remain liable. This was supported by Airedale NHS Trust and Bland, which held that switching off the life support machine amounted to an omission rather than a positive act, so a doctor would not be criminally liable for the patient's death by withdrawing treatment. The final element of the Actus Reus is that the killing must take place under the king's peace for the offence of murder to be satisfied. This means not during a time of war. Where the defendant kills an enemy combatant during times of war, he has a defence to a charge of murder. If both the mens rea and Actus Reus are established, the defendant will be guilty of murder. Murder is a common law offence which carries a mandatory life sentence. The judge will also set a tariff, which is the minimum term the defendant must serve until they may be eligible for parole. If accepted for parole, the defendant will be on license for the rest of their lives. Thank you for watching Law in Layers. If you found this helpful, make sure to like, comment, share, and subscribe. I'll see you next time, as we continue to understand the law one layer at a time.